Live. And it says you are live. Okay. All right, there we go. All right, welcome to a financial planning podcast with a down-to-earth vibe, inspiring Sasquatch to sing Kumbaya with the groundhog too. This is Through the Pines. This week, or this month, or this episode, I should say, we have an exciting topic, and that is estate planning. So some may say, like, thanks, I'd rather just paper cut my fingers, but stay tuned. We're going to make this a lot of fun. We're going to go over why you actually need one and what this can do for you. Eliminate some of the jargon, eliminate the myths, and make it easily digestible for you. Estate planning, if you don't know what it is, we'll cover that first. So our financial wizards this week include Rex Baxter, Brandon Smith, Dan Nelson, and Bryce Froer. So we'll go ahead and bring them in here to the side. There's Bryce, our resident trust expert or real estate. Like, what's your official role, title? What's your job?
So I am I'm an attorney.
Attorney.
With Froer and Miles. We do a lot of estate planning, and I'm happy to join you tonight to answer questions and kind of give some direction on this.
I love it. Also on the Plan with Baxter team, Dan Nelson, Brandon Smith, and I guess Rex is on his own team. So thanks, Rex, for hanging out with us here tonight. Bryce, we'll start with you, I suppose. What is estate planning and why is it important?
So estate planning is the process by which everybody has the opportunity to explain in writing what they'd like to do with their assets after they've passed away. It designates the individuals who are supposed to be in charge. It designates the individuals who are to make legal decisions, medical decisions, and then who specifically is to get the benefits, if there are any, after we've passed away. It's just the plan to deal with your assets when you're gone.
This sounds like so simple, and everyone should have one. Why do they sound painful? Why are people afraid of estate planning with trusts and everything? Like, why is this so hard for us maybe sometimes to get our head around? Because it sounds like something everyone should adopt.
And I would agree that the issue, I think, is that people generally don't like to think about what's going to be happening when they've passed away. They don't want to have to make those kinds of decisions. And yet, like you said, it doesn't have to be complicated. There are situations that are complicated, but it's not a complicated process. And I would say most people should have a trust and a will, primarily to avoid the probate process. And we can get into the specifics of that, but it isn't scary. And some people just don't want to think about those things at this point in their lives.
Rex, let's bring you. I see you have your mic off. Did you want to chime in here from the beginning?
Yeah, so I've worked with Bryce for a long time, and certainly one of my favorite people in the world. But one of the sayings that he says very, very frequently that just has always stuck with me is when you're talking about estate planning, is you're dealing with who gets what when. Did I say that right, Bryce?
That's exactly right. Yeah.
And so that's I think that's exactly what estate planning is about, is who is going to get what and when do they get it. And that's what we're trying to address. And it's amazing at how complex it gets if you don't go through an estate planning process. If I think Bryce would probably attest that he probably, and maybe he doesn't want to do this, but he probably makes a lot more money on those people that don't do their estate planning as opposed to those that do.
I'll be frank. We love to do probate cases where people have died and they don't have a trust, and so we get to go to court. And yeah, that's I shouldn't be saying it like this, but yeah, it's more lucrative to do a probate plan through the courts than it is to do an estate plan initially. For example, just some numbers up front. The probate process typically runs about $3,000 right now to get someone appointed as the personal representative and give them authority to act on your behalf if you've passed away. With a trust, you spend about half that much, and you don't have to go to court. You don't have to involve the court system at all. Statutorily, we are authorized by our legislature, by the state of Utah, and frankly by our congressional representatives, Congress, to distribute our assets to those we wish to have our assets after we've passed away by way of a trust, which is really, really nice.
So, Bryce, is this something that pretty much anyone can have? In other words, if all I have is a retro Ogden City Monopoly game that means a lot to me, and that's all. I don't have a house. I don't have anything else. Should I go through an estate planning process to make it easier when I'm gone?
So in terms of an estate plan, if you have a Monopoly game, you don't need a trust. You don't even need a will. You need maybe a letter to your favorite nephew that says, you know what, favorite nephew, I want you to have my Monopoly game. But if you own real estate, if you have bank accounts, if you have assets that exceed, I'm going to say $100,000, it would probably be beneficial for you to have an estate plan, which would include a trust, just because you would be able to avoid that probate process and have somebody authorized by you to assist you should you be put in a care facility. For example, if Rex were to be in an accident and be unable to speak and unable to give instructions, because he's married, his wife, Jenny, would be able to make those decisions for him. But let's pretend that he's not. If he had an estate plan, he would authorize somebody to make those kinds of decisions for him. Otherwise, somebody has to go to court to get that authority, which is time-consuming, expensive, and a bit of a hassle.
Brandon, do you have a comment on this?
Yeah, I'd just throw in there as well. Oftentimes younger clients feel like, hey, I don't have, maybe especially lately with the housing market, I've got a little bit of equity in my house, my IRAs, 401ks are just getting started. There's nothing significant to speak to. It's just going to go to my kids anyway. But what a lot of people fail to realize is if you have a proper amount of life insurance, which can range, from $1 million, $2 million, whatever, however much life insurance you have. If you and your wife pass away and you both have life insurance, it turns into a significant dollar amount that in my opinion, when I was doing my trust, right, I looked at it and said, man, if I, hit my kids with $2 million when, and they've lost their mom, they've lost their dad, and now they're given at age 18, a huge sum of money, that's enough to ruin just about any kid, no matter what kind of foundation you've given them. And so that for me was one of my main considerations when I did a trust, is I just wanted to make sure that if, heaven forbid something happened to my wife and I, that our kids would be taken care of, and that I wasn't just going to destroy them with a huge sum of money.
Yeah, we can debate on whether or not it's destroying them if they just go out and buy a Lambo, but you never know. So, Bryce, how do we get started doing this? Are there documents we need? Do I have to be wealthy? What's the price range? Is it the more money I have, the more it's going to cost me? Like, how do we get rolling on doing a trust and some estate planning?
Yeah, so for example, when Rex brings in a client, I sit down with them and we talk about what they have and get a feel for where they're at in their life, whether they're near retirement, whether they're young like Brandon, do they have young kids, do they have older kids, who do they trust, and then we talk about one of the questions I ask in terms of, okay, who's going to be in charge, and I'll use Rex just because I know him well enough. If he and Jenny were with me today, I would say, all right, Rex, if you passed away and Jenny was in a care facility, who should be in charge? Who would take care of you the best? And that's the person who we would want to be designated as the successor trustee. As I said a few minutes ago, it's really not. We don't base what we charge on how much you have, but if you own real estate, if you have life insurance, like Brandon indicated, if you have a retirement plan, creating a trust a pour-over will, the durable power of attorney, the medical directive, and deeds supporting documents. That's what we would recommend and try and help you create.
Rex?
Yeah, I think those are a lot of documents, and so we need to probably dig into each of those a little bit as to what each of those are. But I think a lot of times what hinders people from getting started is kind of two things, and one is I'm too young. Like Brandon had said, I'm too young. I don't have a lot of assets, and they forget about the life insurance. But they also lots of times just figure, oh, somebody, my parents will take care of my kids, or or my sister will, and I'll let them know to take care of it. I'll tell them. Well, and that's great that you told them. Appreciate that. And next thing you know, you'll be hiring Bryce to go through all the legal work to make that happen. And so I think one of the lines I hear the most is, am I old enough to have to get my trust work done? And lots of times that comes from 60-year-olds, 70-year-olds, even sometimes 80-year-olds. Am I old enough to have to do that now? And you're probably old enough when you're 25 or 30,
So it's not based on age. It's more based on maybe if you're going to leave anything behind.
Right. That's exactly right. So Dan, how about you over the last 40 years? What have you seen that way?
Yeah, as I've experienced lots of painful situations with clients where they didn't have this work done. As I view estate work, trust work, when you're Brandon's age and you have young children, I think the most important thing you need to know is if something happens to you and your spouse, what happens to the kids? And that's the vital part. What happens to the kids and what happens to the money that will take care of your kids? When you get my age, it becomes important to have that updated and changed, where the kids are raised, they have their own families, you have grandchildren. It is more important as to how do you want your stuff divided up? What is your wishes as far as your what you have in your life and what's important to you in your life, and who would you like that all to go to? And what you don't want, and we see this all the time in this business, is you don't want brothers and sisters fighting over things that they thought were promised to them. And the estate plan sorts all that out. I think that's what's important about it.
Yeah, I've seen it happen, and so and it probably happens more than we would like. So, Bryce, I've seen a list of documents here: a trust document, pour over wills, a POA, immediate versus springing, healthcare directive, medical POAs. I don't know if you want to touch on any of these. You probably dive into these when you're actually talking to a client. But what do we need to know here for this podcast?
So let's start with the easier ones. Let's start on the bottom of that list with the medical power of attorney. Utah has a statute that allows us to select someone. Actually, we in the documents we use, we select two, a first agent and a second agent, to be able to make medical decisions for you if you can't make them yourself. And if you've ever had to deal with HIPAA issues, hospitals won't talk to you, because unless you've got a medical directive or a medical power of attorney is what it really amounts to, they can't share with you information about your loved one. And so as part of the plan that we create, that's one of the documents we prepare for you. We ask you to designate for us who those two people would be. And normally, if you're married, it'd be your spouse, and then somebody that you trust, that in the event that you couldn't make medical decisions for you and your spouse wasn't able to either, that alternate person could give directions to your doctors about what you wanted done. It also includes that living will provision, where you've designated what you want happening in the event life support, living on machines, is an option. And in that medical directive, you indicate what you want done with regard to life support. And so that's the first document. Anybody want to comment on those?
Clear as mud.
So I'll
Here's
comment on that, but just because I've seen that not only with clients and their loved ones and spouses, but also in the family, to where how frustrating is that to be trying to take care of a loved one. You go to the hospital and and they look you in the face and they're like, I just can't tell you anything. I can't share anything with you. And everybody's trying to do the right thing. Everybody wants to do the right thing, but their hands are legally tied. And the last time in the world that we want to have to deal with going and getting documents done and things like that is when we're so emotional, either out of frustration, out of care, out of fear. Those are terrible times to be making decisions and terrible times to get into a situation where you're having to go and get legal work done at that point.
So
That'd be my thought.
If I may, Brandon, I can share just recently, last month, an older couple in their 70s, late 70s, came into my office. Their 45-year-old daughter, who has some mental health issues, was in the hospital in a catatonic state. In other words, she was non-responsive, and they were this close to having the doctors turn the machines off. But because the daughter, again, who's 45, had not created a medical directive, the hospital wouldn't allow them to make that decision. And so we ended up having to go to court to get them appointed as her guardians, so that then they could give instructions to the doctors and make those kinds of medical decisions that a medical directive would have allowed them to do. Fortunately,
I don't think we think about this ever.
Well, and this was kind of a unique exception to what you usually see. You know, parents usually aren't having to make medical decisions for children, adult children, but in this case, it's a good example as to why that medical directive was very helpful. And ultimately, the daughter did come out of the medical condition she was in, and we were able to get her to sign a medical directive, and now her parents can help her out. That's just an example of how helpful those can be in day-to-day situations.
All right. Yeah, go ahead.
I was just gonna say another thing with that is you can also designate what you would like to have happen while you're conscious, while you're thinking. And that can be, in my opinion, one of the nicest things you can do. Right? If it's just nice to make that decision for loved ones, so they don't have to think and say, well, if he were here, what would he want to have happen? And so it can be beneficial that way as well.
Right.
So we're here, Plan with Baxter, the team, planwithbaxter.com. We are talking, this is Through the Pines podcast. We were talking about estate planning, eliminating myths, and defining jargon. Any more of those documents that we mentioned that you want to go over, Bryce?
Yeah. Again, another fairly common one is the power of attorney. And in the notes, we have immediate versus springing. So a power of attorney is similar to the medical directive, except that it deals with legal decisions. For example, Brandon, if you gave me power of attorney, I can do anything you can do as long as I have the document. Meaning I could open a bank account, I could access a bank account, I could sign your name to a deed, I could sell your property. That's really helpful if you're disabled or if you're out of the country and need something signed. And in an estate planning setting, that document we give to the husband and the wife, and then I typically would ask for an alternate. For example, if we had Rex and Jenny, sorry, Rex, I'm going to keep using you. If we had Rex and Jenny here, I would say, all right, Rex, if Jenny wasn't able to make this legal decision for you, of your children, who do you feel confident would make a good decision for you from a legal perspective? The other thing about the power of attorney, keep in mind that those cease to be valid at your death. And some people have the misconception that, well, I have a power of attorney, so I'm fine. That's true as long as you're alive. You've designated somebody to make those decisions for you while you're alive. But at your death, they're no longer valid.
Rex, are we getting into Britney Spears territory? What was this power of attorney stuff? Like, what What power did they have over her?
Well, so that definitely
Is this different?
is no, it's not different. I mean, it's slightly different, right? They set up what they call a conservatorship, to where her dad was her conservator, and then as the conservator, he also had control of her assets as well in that conservator role. And Bryce can talk more about that, but I think on the
He
power
came
of
on to talk about Britney Spears. That's what he mentioned earlier. So
I'm pretty sure underneath that dress shirt he's got a free Britney T-shirt
free
going
Britney
on
t-shirt,
underneath it. I'm pretty sure, but
It's in my desk drawer.
yeah. So I can't tell you how many times over my career, just exactly what Bryce said. People have, we're talking about their assets and beneficiaries, and we're talking about their estate, and how many times they've said, "But Rex, I've got a power of attorney. I'm good. I'm taken care of." And inside, I'm dying and chuckling and everything at the same time, because I know that those cease to exist when they cease to exist. And so it dies with them, and they forget and don't understand that the power of attorney is great while you're living, and a very important document, either to have in place now and immediate, and the springing piece as it springs into action down the road if a certain event happens, is essentially, so if you become incapacitated, then it can kick into effect, or you can set different criteria on that. But it's we do want to clear up that myth that power of attorneys do end when you end. So
yeah, no, I didn't know that, and that's super important. And so just to clarify, because I was a little slow on picking up on what Bryce said, and you reiterated it, but so if someone has a power of attorney, but they die, not the power of attorney, but the power of attorney is alive, so now the person is dead and they need financial decisions made post, the power of attorney has no power.
Correct.
Okay. Yeah, very interesting. Okay, Bryce, moving on here. What is personal property, and how is this handled?
So I want to talk. Let's talk about the trust itself first, if that's okay.
Okay. Yep.
The trust is the primary document in an estate plan, and as Rex said when we started out, the trust is the document that explains those three questions: who gets what and when. So Brandon, if you were to come to me and say, okay, I want to create a trust, you would be the who, right? It's your stuff. You transfer those assets into the Brandon, and I don't know your last name, Brandon Long.
Yep, there it is.
So we'd create the Brandon Long Trust, and we'd move your house into your trust, and we'd move your bank accounts into your trust, and we'd move your account with Ameriprise into your trust. And you would be the acting trustee, and because it's your stuff, you get to decide how it's spent and how it's used. If you become incapacitated, if you get, like my mother has severe dementia. If you get dementia, you're still the who, but instead of you get what you want when you want it, it's you get what you need when you need it. And not until you've passed away do we deal with anybody else getting anything. So the trust is the primary document that first designates who's in charge should you be unable to be in charge, and second, who gets your stuff, your assets, after you've passed away. It's the document that we can use without having to run to court to get permission from a judge to sell your real estate or access your bank account. It's the primary document in an estate plan.
Bryce, when did you first hear the word trust?
In law school.
So that's the problem, right? Like, we grow up and we don't know, and unless someone goes to law school, where do people learn about trusts? Listen to this podcast. How do we get the word out and that kind of a thing?
That's a fair question. That again, with our marketing and Rex's marketing and just trying to educate people how to protect their assets, to get them into the hands of those whom they want to have them at their passing. That's a good question.
Brandon, pipe in, and then I think we need some more numbers. I'm hungry.
You got it.
Yeah.
You got it.
Yeah.
I was just gonna say, I think a lot of times people overthink the trust. It just sounds so big and like only the super rich people need it. The reality is it creates an entity that can much more efficiently execute your wishes. Better than will or anything else. And so that was just my only thought. Is I think that the reason they're not more well known about is so often people think that they're for the movies or for super successful people, when the reality is financially they just make a lot of sense, right? Because they just don't cost that much to get everything put into place. It just makes so much more sense financially just to take care of it and make sure you're protected. So anyway,
Yeah, real quick on that, we do have people like Rex and yourself and Dan who introduce people to trusts. But when, as financial planners, when did you guys first get introduced to it? What did anybody hear about a trust in high school?
No,
Okay.
definitely not. And yet that's when you should be learning about some of these basic things, right? Along with basic financial planning and basic financial budgeting and basic financial matters, ought to be learned, in that high school and college setting somewhere. And so I had learned about them in college, but then again, my focus was on investments, financial planning, had a few law courses, just enough to make me ask silly questions to Bryce, who clears up all my misconceptions. And and so, but most people don't. And so it is an education process. It's interesting. Even this week, I was meeting with a client, and a very successful client. They own probably a dozen restaurants, a couple other businesses, a bunch of real estate. They're getting ready to sell some of their businesses and retire, and they've done none of their estate planning at this point. And so we had a fairly in-depth discussion about the importance and why they want to do it, and kind of drew out some numbers as to what it's going to cost them if they don't do it versus what it'll cost them if they do. And it's a pretty unbalanced scale. It costs them a lot more to not do it than to do it. And yet here we are dealing with somebody that's in their 60s and they're just barely kind of figuring that out, and lucky nothing happened to them when they were 30, 40, or 50. But that's not always the case. You just don't know. You can't predict that future. And so it's, kind of the old Boy Scout motto of always be prepared, right?
Yeah, I just really want to know if it's in the curriculum anywhere in high school somewhere. Dan, do you remember the first time you heard of trust? No,
I sure no, just to college probably. And It's interesting, Rex, that you say that, because I did a trust years ago, but I went to my wife, tried to get her involved in this, and she's a dance teacher, has a dance studio, kind of an artist, not into any numbers whatsoever. And she said, I don't want to sign that. And I said, well, why not? Why didn't you want to sign it? She says, because as soon as I sign that, I'm sure I'm going to die, And so I think you have people that kind of think that way. It's kind of like buying life insurance. You don't want to buy life insurance because then, that's something bad's got to happen in order to use it, And the same thing with the trust. That's how some people look at it. And so I'm a classic example of I've got to get that updated and get that done now at this point in my life. And I'm just lucky that I signed it. I signed I think we had two trusts actually. I signed mine, but I don't know that she ever did sign hers. So,
oh, interesting. Brandon, let's get some numbers in here.
Okay. I've got to say, on the opposite side of that coin, though, it feels so good to just know that everything's taken care of. Like if something happened to me, my kids are going to be taken care of. I'm not going to put a financial burden on whoever's taking care of my kids. They're not going to have to sort it out, fight about it between family. I mean, it's just so nice. Feels so good.
totally.
And good. I haven't died yet.
Don't do that.
I was going to say, you look good for a dead person, Brandon.
Thank you. Let's get into some more numbers. Cars. So Rex and I typically, when we advise people on sound investments, new and used cars don't come in at the top of the list. But recently, the price of new vehicles increased by 11.8% in 2021.
Are we flipping cars now? Is that what we're doing?
Well, hold on. It gets better.
Okay.
That number is dwarfed by the 37.3% increase in used cars and trucks. That was according to the Bureau of Labor Statistics. Yeah, that's just crazy.
I had someone tell me that I should trade in my car because I get a lot of money for it. And I'm like, it's the same thing as selling your house. Well, now I got to go buy another car. So what the hell good does that do? I don't know. Oh, yeah. Rex.
Hey, talking about cars, let's flip cars. We'll flip it into estate planning. How are cars handled, Bryce? Because I get this question all the time of, on my vehicle or my RV or, my trailer or whatever the case may be, my van that I drive around and play music in, whatever it is, right, Brandon?
You have one of those too?
No, I just envy somebody that has one of those. So how are vehicles handled in estate planning?
Yeah, so I get that question fairly often. Should I put my car in my trust? And my answer is no, because of the liability issue. And again, lawyers create sometimes more problems than they solve. But if you put your car in your trust and the trust is the owner, then potentially if there's a bad accident that you caused, the owner of your vehicle can be held liable. And so my advice is, look, don't put your car in your trust, but do have ample insurance to cover any kind of accident that there might be. So then the question is, okay, well, what happens when I die if my name is on the title? Again, statutorily, the state of Utah allows us to if, for example, if my mother dies, I can take the title to her car with a death certificate down to the DMV, and they will change the title to that car to anybody that I designate. Now, there's an exception to that, and Brandon was kind of referencing that. As long as the car is not worth more than $100,000. For example, I have some friends that live down in St. George, different friends than Rex, because he lives in St. George. And we visited them over Thanksgiving, and they're both retired. And he says, hey, do you want to see my Bentley? And I said, oh, yeah, I've not ridden in a Bentley before. And he says, yeah, we got it for a steal. We got it for $150,000. And I thought, oh, well, we need to put that in your trust because that can't be transferred by way of DMV and a death certificate because it exceeds that statutory $100,000 value. So I think that's what I would say about cars and trusts.
Give it about 6 months and the Corollas are going to be $102,000. Yeah, it's only going up. Rex, do you have any other comments on that?
Well, other than the 10 van is priceless, and so it definitely needs to be in the trust.
Thank you so much. I appreciate that. Yeah.
Yeah.
No, it's been nuts. Thanks, Brandon, for those more numbers. What are some of the common roles and responsibilities in what's going on here? The trusts or the estate planning, the personal representative. I have the bullet point list here, Bryce, so you can help us out. Trustee, successor trustee, beneficiary, and a lot of us have heard some of these terms, and we just kind of might need to be reminded of how they are applicable. A power of attorney, which we've talked a lot about already, a guardian, and a conservator. So what's some of the difference between some of these? Again, the only thing I know and care about is Britney Spears. And so I heard a lot of conservatorship, that word thrown around in that case. And how is that different from, a personal representative or a trustee, et cetera?
Okay, so let's talk about guardianship and conservatorship. In your healthcare directive, you will designate who you want to serve as your guardian if you need a guardian. And so, Brandon, if you're a danger to yourself or a danger to others, I'll use my mom as an example. If she gets to the point where she walks outside and can't figure out how to get back to her house, we will need to have a guardian appointed for her because a guardian is over the person, right? The guardian would decide where the person lives, who the person sees, what medical treatment the person receives. They're in charge of the person. It's kind of like a parent-child relationship. conservator, on the other hand, is over the assets. And when you say Britney Spears, where her father was her conservator, her father was over all of her assets. And so she didn't have any control because she'd been declared incapacitated to a certain extent by a judge. And not until recently was that conservatorship lifted. Whether she needed it or not, I don't know the specifics about it, but her father was in charge of the millions of dollars that she had and was earning, and he decided what money she had available to her. He decided what she could buy or what she couldn't buy. And again, I'll use my mom. If she becomes so bad that she can't manage her money, she's designated in her estate plan who she wants to act as the conservator, who she wants to be in charge of her money. That's a huge benefit for, usually it's our senior population that needs help. I'll give another example of that, though. We just last week, I guess it was, I was in court with a young man who was 19. His mother and his sister had petitioned the court to be his guardian and his conservator. Because he's got some mental health disabilities, he needed that help. And so now he has a guardian that takes care of him, and he has a conservator that takes care of his assets. And what assets does he have? Well, right now, the little bit that he has coming in from Social Security is managed by his mother and his sister, and that will be very helpful to him. Does that make sense?
Yeah, no, I didn't realize you could have multiple roles involved, which is good. Okay, so of state funding.
So let me back up to your list again. Let's talk about.
Please do.
We've talked about the power of attorney. Let's talk about the titles in a trust. Some of the common roles and responsibilities question you asked. So in a trust, there are several titles. We have first the grantor, or the trustee, or the trustor, and that's the person. For example, Brandon, if you came into my office and you said, you know what, I want to create a trust, we would designate in that document that you are the grantor or the trustor, you're the creator. And the trustee, that's the person that's in charge of managing the assets that are in the trust. And as long as you're competent, you get to be the trustee of your trust. If you become incapacitated, I'll say Rex is your designated successor trustee. In other words, he would be responsible to make sure your bills are paid. He would be responsible to make sure that you were taken care of with whatever assets you had, with the tan colored van you mentioned.
Thank you. Tan van. Yeah, I 100% trust Rex with my tan van. It's very scary.
Then the other title that we reference in a trust is the beneficiary, right? And so again, after you've passed away, Rex would be responsible to make sure your debts were paid, and that whatever assets there were left would be distributed to Dan and Brandon.
All I heard was that if I die, Rex has to pay my debts.
With your assets.
Oh,
with your money, Brandon.
Your money.
Oh, my money. Okay.
Yeah.
Okay.
And so those are the titles that we would reference in a trust: the grantor, the trustee, a successor trustee, and the beneficiaries. Now, there are clients that are very, I'll call them old-fashioned, who think that their successor trustees should be their children in basis of how old. The oldest is the trustee, and the second oldest is the successor trustee. I try to dissuade them from doing that, because it's an old tradition, I guess, that people have that perception that the oldest child, whether it's a son or a daughter, should be in charge. That's not true. The one that should be in charge is the one that you trust the most to take care of you the best.
But let's be real, that's usually the oldest, right?
Well, I'm the oldest. Yeah, I'm going with that.
Me too. I'm just
pretty sure it's the youngest.
The third child.
Yeah.
Third child.
Dad's 3. Yeah. Okay.
Third child.
So in my situation, Brandon, when my parents created their trust, they designated 3 of us, the oldest and 2 in the middle. And whether that's right or wrong, that's what they wanted to see happen. And I have 7 siblings. We're a family of 8, and some of the other 5 are, I guess, a little bit offended that we're in charge and they're not.
I mean, it is what you do for a living.
Well, yes. The other comment I get, and I hope this will make you laugh, is we get a lot of clients that come in and say, I just want to be fair. I just want to make it fair. And my dad would say, you know what? Fair is where you go to see pigs and chickens. It doesn't have to be fair.
Yeah.
It's what you want it to be.
Okay. So, I mean, I don't think people understand the gravity of the choices that are made when somebody passes, and then how immediately the close family members can turn on each other, not necessarily because they want to, but just because they, like you said, they thought they were getting something and they didn't, or or something like that. And so does this clear up having a decent trust pretty much all of that stuff, or are there still some issues that maybe families will be dealing with?
So my response to that would be 95% of the time a trust will take care of it. There are occasions when a family member just is so offended and so upset that dad didn't leave them a bigger share or didn't leave them the family heirloom that they want to take action in court and contest the trust. And as long as the trust was executed properly, they will not be successful. A lot of my clients also will say, you know what, I want a provision in my trust to say if anybody disagrees with it, they get $1. And those are enforceable. It's unfortunate that kids get angry and get offended. But again, I'll go back to fair is where you go to see a pig or a chicken. It's what the client wants to have happen. And sometimes they treat kids differently. Sometimes it is equal. Most of the time it is equal. But sometimes there's kids with special needs, kids with that were given a challenging life through no fault of their own that the parent wants to take care of a little differently. And they get to do that. That's the nice thing about, one of the nice things about trust is that there's no wrong way to distribute your assets. You can treat everybody equally. You can give everything to one child and nothing to other children. I have clients that say, you know what, I have a son or a daughter that has a substance abuse problem, and if I give them $10, they'll spend $50. And so I don't want to give them control of anything. I want to help them, but I don't want to give them control of anything because I don't want to continue to contribute to their addiction. And with a trust, you can do that. They're a really great tool for managing assets for those that come after us.
Brandon, you have a comment?
Yeah, trusts are cool in the, I mean, you watch the movies, right, where
trusts are cool. That's all we need to know. Trusts are cool.
I'm going to explain how cool they are. No, you watch the movies and there's the crazy parameters. You can get this, but you have to do X, Y, and Z. That's real. Like, you can really write that into a trust. And obviously, I don't think you're trying to make a family, TV series off of your poor kids. Inheritance.
It'd be a fun game if you have to make somebody like go to the restaurant here and then do this and then do that before they can get whatever they get. That's kind of fun. I don't know how detailed you can get in that stuff, but
you can go all the way, right? You can do whatever you want. And I guess I say that not so much to try and make a scavenger hunt for your beneficiaries, so much as if you've got kids and you're really worried about them and you really want to take care of them and you've come up with a way that you think you can help those kids or beneficiaries in the best way, you can specify those parameters however you'd like, right? That's why a trust isn't just a one set thing that you sign here, write your name here. Like, Bryce can actually design that and build that out exactly how you would like to see that executed. I know for me, I want my kids to have experience with some money, but not get all of it lump sum, right? And so there's different ages at which I give my kids a portion of that. And so trusts really are, they're dynamic, and you can modify that and create it so that it, whatever you want to have happen happens when you want it to have happen to who you want it to have happen to. And it seems to me anyway that most of the disagreement comes when the beneficiaries have to make a judgment call. If you've specified it and it's like, wow, this is the way mom and dad wanted it, there's a lot less contention than if you leave it up to a trustee, which I've seen, and it just makes me cringe, right? When the trust says, leave it up to this person to divide this however they see fit. It's like, I wouldn't wish that responsibility on anybody, right? Sure, you've got all the control, but nobody's going to like you afterwards.
Yeah.
So anyway.
Rex, you have a comment?
Yeah, a lot of disagreements that I see don't necessarily come out of the trust, but a lot of them come from when, dad promised his favorite rifle to, son number one this Christmas, son number two, 2 years from now, and son number three 3 years from now, and then he passes away and he's promised it to all three sons over the years. And so now all three sons think that they're getting the gun, and that's where the fights begin. And so, Bryce, how do we handle situations like that where it's not, it's easy to split $1. I've heard you say that a million times, right? It is easy to split $1, but it's not easy to split a wedding ring.
Yeah, so I'll use a personal experience with my wife's family. My mother-in-law, she received an old sapphire ring from her mother, who got it from her mother. And we figured, we calculated that this sapphire ring came into the family in about 1905. And it's probably not worth $200 or $300, right? But it's not a valuable asset from a monetary value, but sentimentally, it's priceless. And Rex's example is exactly what happened. My wife comes from a family of 6, and 5 of those are girls. And my mother-in-law, in her wisdom, promised it verbally to 3 of the 5, my wife being one of them. But she never wrote it down. She never designated it in a document to say, okay, this ring is to go to this daughter. And so when she passed away, because she passed away before my father-in-law, all of the personal property now belonged to my father-in-law, including this ring. And he held on to it. And fortunately for my wife, on one of her birthdays a few years ago before he passed away, he gave it to her as a gift for her birthday, which she loved it and wears it proudly and is grateful to have it. But it did cause some strife with the other 2 sisters who had been promised that ring verbally. So what we do to avoid that, as Rex was alluding to, as part of our estate plan documentation, we refer to a letter of instruction regarding personal property, and that's exactly what it's called. And it's interesting, that's the hardest thing I have to get people to do, because you have to sit down and say, okay, the 30-06, I want that to go to Brandon, and the dining room table, that's going to go to Dan, and the ring is going to go to Jenny. Those are really hard choices for people to make. And so when I say that's the hardest thing I have to get people to do, that's true. And I say to my clients, I say, look, you know what? If your kids argue about it, if we have 2 of them saying, well, Dad promised me that, no, he promised me that, you can take it to court, and you can imagine a judge saying, I don't know what to do with it, sell it and divide the dollar, because I can easily split up how we deal with the dollar, but I can't look in your parents' mind after they've passed away and know what they wanted to do with this asset. So that's really, really important as part of the estate plan, that people write down and sign and date that document what they want done with their personal property. So the tan van, Brandon, who gets the tan van?
Yeah, right now it dies with me. Yeah.
It's pretty hard to bury you in your tan van.
Right. Dan, you have a comment?
Let me ask a question. Instead of writing it down, what about a video, audio, tape, a conversation where you're talking about those things? How's that play out?
I think that would work. The statute designates, so the statute regarding trusts indicates that if you've written it down and signed and dated it, that's what the court would look for. But I think we're technologically enough advanced enough that if you sat down in front of a video recorder and indicated the date, the time, indicated that you knew what you were doing, and that it became an issue, that a court would take that as evidence and indicate, yes, in fact, this is what Dan wanted to have done with regard to the personal property.
Okay.
I've had some clients take pictures and write on the back of the picture who they wanted to receive the asset. That too would be a writing that would allow for that asset to be distributed to that individual.
Great information. Thank you.
Yeah, super interesting. So, Bryce, we're with Rex and Brandon and Dan, and they are fiduciaries as part of their, that's their job. What is your role? What do you do? Is it a fiduciary type position as their attorney? How much can you influence, or, how do you walk someone through the process?
So, I don't know. We wouldn't be considered a fiduciary because we don't hold any of their assets. What we would be considered as advisors or counselors, and in preparing the documents, hopefully do it in such a way that the documents, if they were questioned or contested, I'll use that word, that the court would say this is done properly and is enforceable. And that comes with, okay, did we follow the statutory guidelines that are outlined in the Utah Code with regard to trusts? Do we designate that it is a trust? Did we have the trustees designated? Do we have the beneficiaries designated? Was the individual competent at the time? And is it executed properly? Is it signed and dated and notarized? And so we would walk the client through all of those steps, and then I'll use Ameriprise as the example. If they have an Ameriprise account, we would work with them to get that asset transferred to the trust so that the successor trustee, if they become incapacitated, is able to manage the assets. And if they pass away, the successor trustee can then distribute the assets without Rex or Brandon or Dan having to say, well, you're going to have to go to court to get appointed as personal representative to be able to tell us what we can do, because we can't talk with you because you're not designated in the document.
Yeah, I was just curious because I didn't know how many times the upset brother or sister was mad at you. It's your fault, Bryce, because you were there.
It happens. And that's one of the reasons why when we meet with people, they can't designate us as a successor trustee. They can't designate us as a beneficiary. That's against the rules. We can't receive anything other than what we charge for our time to prepare the documents and execute the documents. Otherwise, we create a conflict for ourselves.
Yeah. Rex.
I think one of the things that I really enjoy about Bryce and working with him over the years is that he does an amazing job of staying agnostic to kind of his biases or his own personal feelings and experiences as far as influencing or counseling his clients. But he does a phenomenal job at providing examples, just like the ring example, of what can happen in different situations depending upon what the clients decide to do. And I've worked with a number of attorneys, and it's always frustrating when I've seen an attorney that says, hey, look, you need to do it this way because my friend went through a divorce, and because of that divorce, this happened. Therefore, everything has to stay in your name. And that's right for everybody, period. And that's not right for everybody. I think there's not anything that's right for everybody necessarily, other than probably getting their estate plan done. But I mean, I think he does a great job of not influencing. And I think that's the sign of a great attorney is being able to share, pros and cons and examples and the good, the bad, the ugly of different choices legally of what can happen. And then I truly believe that people are smart. People can make up their own mind as to what's good for them and their family and their decision if given all the facts and the examples that they need.
Yeah. Bryce, Rex used the D word. So we should maybe cover what happens in a divorce to the trust and how is that laid out? How do you divvy that up if something like that were to happen?
So we deal with that fairly regularly. In addition to estate planning, we do family law, and yeah, it comes up. There are statutes in place that, for example, if Rex and Jenny are married and Rex has life insurance and he names Jenny as the beneficiary of that life insurance policy, and then they get divorced, because of the divorce decree, that changes that beneficiary designation automatically. And so there are provisions there in place. With a trust, that's not also true. So if I have a trust and I list my wife as my beneficiary, and my wife and I get divorced, and I don't change my trust, the court will enforce my trust. And so, yeah, if there's a divorce, if your children get divorced, and you have listed your daughter-in-law or your son-in-law as one of the beneficiaries, that stays unless there's an amendment made. And it's not hard. Brandon mentioned trusts are great. They are great. They're easy to create, and they're easy to change. And so for example, if there was a divorce, it's just an amendment to the main trust that has to be done. You don't have to redo the entire trust, which makes it really convenient to just have an ongoing relationship with your attorney, your financial advisor, to make sure that things are in place.
Yeah. All right. This is the Through the Pines podcast, and we are talking about everything for, the not retirement, what happens when you go, the eliminating the myths, the jargon of all of this estate planning trust stuff that we'll call it stuff when we don't know, because Bryce is the only one who knows all of this stuff. That's why we go to Bryce. So we're getting towards the end of this thing, but there's different kinds of trusts. So I don't know how much we need to know about all the different kinds, but why should we use certain ones over others? Revocable, irrevocable, family, a bypass trust, asset protection trust, there's special needs, and then this is my favorite part, T-crat, crat, grat, clat. It's like, what is all of this language at the end down here that I'm seeing, and why are all of these? Do we need multiple kinds of trusts?
I think that's a great teaser, Brandon, for our next podcast. I think that I think we just tease everybody with T-crats and grats and zero T-crats and everything else that I feel like that old commercial where the lions and tigers and bears, oh my, right?
Yeah.
Kind of thing. So
it's all acronyms, and I'm sure they're very important, and I'm not here to make fun of them, but I have no idea what they mean. So yeah, but there are different kinds, and so maybe we can just gloss over, like, what do we, which one's important to maybe establish first or something like that.
Let's just talk about maybe have Bryce talk about revocable versus irrevocable really quick, because that's one of the ones that comes up a lot, and kind of oversees a bunch of the other kinds of trusts.
Yeah, so the most common trust that we create for our estate planning clients is the revocable trust. And it is what it sounds like, meaning it can be changed, it can be revoked, it can be amended. And for an estate plan to outline who you want to be in charge if you become incapacitated, and who you want to receive your benefits after you've passed away, the revocable trust is the best option for most people, because you remain in charge. Again, Brandon, if you came to me and said, you know what, I want to create a trust, I would say, all right, we're going to do a revocable trust, because you're in charge and you can change this anytime you want. Once you become incapacitated, it becomes irrevocable. Once you die, it becomes irrevocable. And so that title, an irrevocable trust, we don't do those very often because you lose control. Occasionally, we'll have a client come in and say, you know what, I want to create a a trust to hold property that I benefit from, but that I don't control. And so we will create an irrevocable trust. But they have to understand that they no longer control that asset. The trustee controls that asset. Usually the trustee will be a family member, someone they trust to use the asset as it's supposed to be, but that person who created it loses complete control. And so we don't do those very often. Even when our clients are in their 70s and 80s, as long as they're competent, my advice to them is, look, you've lived a lifetime managing your stuff. There's no reason that you shouldn't continue to manage your stuff. And so we create those revocable documents for them because they want to be able to continue to access their bank accounts or sell their property or buy a new car without somebody else's permission.
Yeah, good stuff, Bryce. Thanks so much. I appreciate it. Estate planning, eliminating myths, and defining jargon. We have more. We're going to break this up. We have another podcast that will talk a little bit more about estate planning. So thank you so much, Brandon Smith, Dan Nelson, and Rex Baxter. For more information, if you'd like to get in touch with any of these fine gentlemen on the podcast today, visit planwithbaxter.com. I am R. Brandon Long, and this has been Through the Pines, reminding you to use yesterday's dollars to finance tomorrow's dreams.